Distinguished guests, ladies and gentlemen, on behalf of the School of Economics at the University of Queensland, it's my pleasure to welcome you all to the 21st Colin Clark Memorial Lecture. This is a very special event for UQ. It's an opportunity for us to celebrate the achievements of Colin Clark, but also to engage with the broader community here in Queensland. We have always aspired to bring to you outstanding economists who have played important roles in the development of the knowledge frontier in economics or have been influential in policy development. Today's speaker, Professor Stephen King, has actually done both. But before I formally introduce Stephen, I would like to share with you some of our recent achievements. As you might be aware, researchers from UQ's School of Economics have received more than $1 million in this year's round of the Australian Research Council Discovery Grants. Across the country, the success rate is around 20%. I think our success rate in the school is about 80%, so 4 times larger than the success rate across the country. In fact, the school received 20% of the total number of grants awarded for economics across the country, and 50% of the total number of grants awarded for econometrics Australia-wide, with Monash grabbing the other 2. The school also received the only Discovery Early Career Research Award in economic theory in Australia. Our success, however, is not limited to research grants. Colleagues from the School of Economics, Phil Bodman and Alan Dewes, received an Australian Learning and Teaching Council, or as it's better known, ALTC, citation for outstanding contributions to student learning, and Carl Sherwood, who I believe is here today, maybe not listening, but yes, he is, received a citation at UQ Excellence in Teaching Learning Awards for 2011. And these achievements, they consolidate our position as one of the premier economics departments in the nation. I want to take this opportunity to congratulate all those that are behind our recent successes, and some of them are here today, and to thank them for the efforts on behalf of the school and the university. And talking about thank yous, I would like to acknowledge the help I had in organizing today's events. First, I would like to thank Queensland Treasury for providing financial support, and the Economic Society of Australia for their continued support. Thanks also to Margaret, Rach and Louise in the School of Economics for doing an excellent job in organizing all aspects of this lecture. In fact, if you don't mind, I would like you to say thank you to them. And I'm sure Margaret will like to come here and... no, she wouldn't. Okay. All right. I'm also pleased... Sorry, Margaret. I'm also pleased to acknowledge a member of the Clark family attendance, Christopher Clark, who is one of Colin Clark's sons. He's also attending. It's now time, though, for me to introduce Professor Stephen King. Stephen is the current Dean of the Faculty of Business and Economics at Monash University. Prior to joining Monash University, Stephen was a member of the Australian Competition and Consumer Commission, and before that he was a professor of economics at the University of Melbourne and a professor of management at the Melbourne Business School. Stephen's main area of expertise are in competition economics, regulation, and industrial organization. While at the ACCC, Stephen was the chair of the Mergers Review Committee and was closely involved in a wide range of merger decisions. He was involved in the full range of activities undertaken by the Commission, and these include regulatory authorization decisions, regulatory determinations, and enforcement acts under the TPA. Stephen's research in industrial economics has been published widely, including articles in top international journals such as the Journal of Political Economy and the Journal of Industrial Economics. I would now like to invite my former colleague and longtime friend Stephen King to the microphone to deliver the 21st Colin Clark Memorial Lecture. Thank you.
All right. Thank you, Flavio, and thank you for those kind words. I'd like to start by saying a few words about Colin Clark, and I'm going to give a quote. The quote is, for those of you who have the paper in front of you, the quote's at the beginning of the paper. So Colin Clark's name is at the very forefront of those who have shaped the subject of economics in the 20th century. Colin Clark's career is testimony against such present tendencies as there are to divorce economics from current human concerns. Although he has worked within a rigorous framework of economic theory and a search for empirical regularities or laws governing economic phenomena, his attention has always been focused on large social issues. His name is immediately brought to mind by mention of such major problems as the process of economic development, population growth and food supply, macroeconomic forecasting and policy, the limits of taxation and the optimal size of cities. His choice of research areas has never been inhibited by narrow consideration of scope of economics. Wherever his social conscience and penetrating intellect have led him, he has followed. It has never crossed his mind to accept the conventional wisdom uncritically or to refrain from exposing its inadequacies. So these words describe one of the greatest economists of the 20th century. They're not my words, as I said. These words were spoken by the former dean of my faculty at Monash University, Gus Sinclair. Gus delivered those words when honouring Professor Clark with an honorary Doctor of Economics degree at Monash in 1983. So it gives me great pleasure to be here today to deliver the Colin Clark Lecture. I'm not going to dwell on Professor Clark's stellar career with Oxford or Cambridge universities, working with leading lights such as Keynes and Pigou, with the Queensland Government, with Australian universities, including the University of Queensland and Monash. I'm not going to dwell on the accolades he received in his lifetime and his standing alongside numerous winners of the Nobel Prize for Economic Science. Rather, I'd like to begin this talk by passing on some brief recollections of Colin Clark's life from his colleagues of almost 10 years at Monash University. And talking to my colleagues, three things became apparent very quickly. Firstly, Professor Clark was an exceptional colleague whose passion was applying economics to the real world. Second, Professor Clark was a towering intellect. He was the person who always asked that polite but insightful question at seminars to which the speaker can only reply, "Oops." And third, Professor Clark was a man of great principle. He sought to make a real difference to Australia and to the world. Now, interestingly, the graduation speech that Professor Clark gave when he received his honorary doctorate from Monash University could have been delivered today in the context of Europe. He talked about appropriate government policy to deal with high unemployment and looked at the efficacy of decreasing taxation versus increasing spending on public works. Now, what I want to cover today involves a very different but I believe equally important area, the role of government in setting regulations and rules in the marketplace. My hope is that in 20 years' time, my talk today will be as relevant as Professor Clark's talk from 20 years ago is relevant to us today. I want to start by considering the topic. So, competition regulation. Some people view that as being just a contradiction in terms. Competition and regulation are alternative ways, they would say, to organise economic interactions. From their perspective, regulation limits competition by restricting economic interactions, and under such a view, regulation would be the antithesis of competition, Competition regulation would be a contradiction in terms. Now, in my opinion, that view is simply wrong. And it's clearly wrong. Let's start by thinking about the laws that underpin the marketplace. Without the law, without laws governing property rights and without rules of contract, there would be no market interactions. If I wanted to do a deal with Flavio to sell him something that I own, but there were no rules of property rights, then Flavio would have to be a fool to do the deal. He'd simply grab a great big baseball bat, and Flavio, being very fit, probably threatened me with the baseball bat, and I would hand him over the goods. They would be his. There would be no rules of property rights. You cannot have trade in the absence of laws of property rights. Similarly, you can't have trade in the absence of laws of contract. If there were property rights but no rules of contract, Flavio and I may reach a wonderful agreement. Here, Flavio, I'll sell you this, you'll give me $100. I pass him the goods. I say, Flavio, where's the $100? He says, what? Oh, you signed this bit of paper. You said you'd pay me $100. There's no rules of contract. It's unenforceable. So at a minimum, to actually have economic marketplace interactions, you need regulations of property rights and contract. Some rule of law is a necessary precondition for the existence of economic transactions in a market. Now, most markets have a lot more regulation than just that minimal level. By competition regulation, I'm going to focus on a particular set of laws established by governments around the world that aim to improve the functioning of market-based transactions in goods and services, and I'm going to exclude labour services. Now, in Australia, those rules are embodied in the Competition and Consumer Act 2010. Now, that was formerly known as the Trade Practices Act, and hopefully I won't make my usual mistake of calling it the wrong name. Professor Coronis is at the back to throw things at me if I make that basic mistake. Now, I'm actually going to only focus on one part of those rules, the particular subset of what is in the Competition and Consumer Act that are generally called antitrust laws. Now, antitrust laws have a long history, but a bit of a checkered history. Antitrust laws developed in the US in the late 1800s. They slowly spread around the world, but it was a very slow spread. For example, if you look at Europe, say Germany in the early 20th century, the idea of having laws to ban cartels would have been laughed at. There was a view that cartels, businesses getting together to agree upon prices, to not compete, there was a view that that was good. The alternative was nasty, cutthroat competition. Competition that could lead to some businesses going bankrupt. So in Europe in the early 20th century, the sort of antitrust laws, the laws based on the Sherman Act in the US, which made cartels illegal, they would have been laughed at. It was only in the 1950s, with the Treaty of Rome, that Europe embraced modern antitrust laws. In Australia, we have a distinguished history of failure in antitrust laws. The first attempt to introduce antitrust laws in Australia occurred pretty soon after Federation. I think it was 1904, 1905. They failed for constitutional reasons. Essentially, the first working version of antitrust laws we had in Australia was 1974. So it took the best part of 3/4 of that century to get policies in place to regulate cartels, abuse of market power, mergers and so on. And in fact, it's arguable that Australia really didn't have a national competition law until 1996, when, following the Hilmer Report, the states passed mirror legislation so that all of the exceptions that existed to our competition laws were brought into the competition laws, that they could be claimed to be truly national and truly have universal coverage of a marketplace. So we've made a lot of progress in Australia, but it has taken a long time to get to where we are today. So what I want to do is give a report card on where we are today and where we're going. I'm going to focus on 4 things. What I'll call the bread and butter antitrust laws, cover 3 of them: cartels, abuse of market power and mergers. But I want to spend the last part of my talk talking about regulatory innovation, because that's the part that I find really exciting and, quite frankly, the bit that Australia is doing really well at. So for those of you who find the first part of my talk a bit negative, get stuck into poor old Aussie and don't give poor old Aussie very good marks, Aussie looks better at the second part of the talk. Okay, cartel laws. Let's start with that. Now, Australia's cartel laws are broadly in line with other Western countries. Like the US and the EU, we have broad laws against price fixing and anti-competitive arrangements. Simple example from Section 44 ZZRF of the Competition and Consumer Act. Section 44 by itself of the Competition and Consumer Act is probably bigger than most other acts as far as I can tell. And I will ask Stephen later on as to why on earth lawyers have to go to ZZZs and so on in the legislation. But as an economist, couldn't you just have gone to 45, 46, 40 and just renumbered things, for God's sake? So a corporation must not make or give effect to a contract, arrangement or understanding that contains a cartel provision. Okay, well, what's a cartel provision? That's defined as a provision relating to price fixing, restricting outputs in the production and supply chain, or allocating customers, suppliers or territories, or bid rigging by parties that are or would otherwise be in competition with each other. That's pretty well worded law. That captures most forms of price fixing that we would be worried about. It's not simply prices. If you allocate markets, you say, hey, you take the south side of a river, I'll take the north side of a river, that gets captured. If in a government bidding process, you do something like say, well, hey, look, I want to win this time, so how about you put in a bid just under mine, some sort of covering bid, you've violated the law. So we look like a lot of other Western countries. We've got criminal penalties now for breaching our cartel provisions, like other Western countries. We've got a leniency policy to encourage whistleblowers. All looks good. So we're not outstanding, but surely that's worthy of, say, a B on our report card. Unfortunately, I think there's a fundamental problem, and the problem relates to the words contract, arrangement, or understanding. And it relates to the way that these words have been interpreted by the courts. In my view, legal decisions have led us to a point where, basically in the absence of recorded conversations, it's almost impossible to find a contract arrangement or even an understanding, unless it's absolutely clear. It's difficult, if not impossible, to infer an understanding from behaviour. What do I mean by that? Well, let's imagine that I'm picking on you, Flavio. Do you want me to pick on Paul instead? I'll pick on Paul. Let's imagine Paul looks like a rogue. Paul and I happen to be in, let's say, Ballarat. Those of you who know the case law behind this will know why I'm picking Ballarat. We happen to own a couple of petrol stations, and Paul's down the road from me. And imagine two conversations. Imagine that I ring up Paul and I say, Paul, mate, time for prices to go up, Paul. There's two ways that conversation can go. The first way, which would be the silly way, would be Paul happens to turn on his tape recorder, which he has sitting there, as he does, and to say, Stephen, mate, that sounds like a good idea. I'll put up my prices as well. Let's screw the customers. Or if he didn't have the tape recorder, but when someone from the ACCC comes knocking, Paul could say, oh yeah, this is the conversation that I had. I told Stephen that he puts up his price, I'll put up my price, and we'll screw the customers. Now, if Paul did that, we would both be sunk. That's fine, it's clear, we've broken the law. The court would find us guilty. Let's imagine Paul's a little bit more subtle. Let's imagine that Paul says, Stephen, mate, interesting to hear that you're putting up your prices, but as you know, I make my own independent business decisions. I may or may not put up prices as well. Hear from you next week. And that's all the conversation is. Paul has made it clear he's making his own independent business decisions. Sometimes he does follow my price up. Not always. Fair few times, but not always. He follows my price up. as would be, by the way, perfectly sensible from an individual profit maximising decision. If your competitors are putting their price up, well, it's profitable for you to put your price up as well. That would mean that Paul would get off and I would get off. There would not be an understanding as it has been interpreted by the courts. And I think that's simply far too narrow. We've got to a point in Australia where careful conversation should mean that parties can avoid prosecution. And that key is to make it clear that happy to have a conversation, but you make your own unilateral profit maximising decisions. I think that's a problem because the sort of conduct that would probably be found guilty in the US and almost certainly would be found guilty in the EU is not found guilty here. And that I think we're going to see over the next few years very smart business people with very good legal advice being able to reach what I would call an understanding relating to prices, but would not legally be breaking the law. How has the government responded? This is the problem. How has the government responded? The government response is completely bizarre. They've come up with new price signalling laws that are going through Parliament. That's actually not a bad response, except they're limited to the banking sector. So we're going to fix the problem for the banking sector only. The laws are written quite generally, but as they go through Parliament, they will apply to banks. Now, the rules themselves, I think, are half good, half bad. The rules against private exchange of price information will make it very clear that the sort of conversation that I had with Paul, even if Paul's not breaking the law, I will be. If I'm a competitor of Paul's and I privately give him information about my prices, I will have broken the law. It's unilateral. And quite frankly, I think that's a pretty sensible thing. It's pretty hard to think of a lot of situations where petrol retailers would be acting in the public interest by privately exchanging price information. Exchanging price information in a way, yes, where's Informed Sources based? Up here, isn't it? No one from Informed Sources in the audience. In a way, exchanging information privately in a way that is not available to the public in their contracts. It's pretty hard to think of a situation where that would be in the public interest, or where other retail sectors should be privately exchanging this information in a way that is not available to the public. It's pretty hard to think about a situation where that wouldn't be an attempt to fix prices. If there are situations, and the banking industry quickly got out their consultants and they thought up a couple of ways where private information exchange may be useful, those exchanges can be authorised by the ACCC. In other words, you can go to the ACCC and say, look, this would be against the law, except we believe there are public benefits that outweigh the competitive detriment. They should be made legal. And the ACCC, if you convince them, the ACCC will authorise those. So there is an escape clause in there. So this seems to me to be pretty good law. Why on earth does it only apply to the banks? The second part of the rules are rules against general disclosure of strategic information for an anti-competitive purpose. I won't go into that because I think it's completely unenforceable. It's far too broad in terms of what it can potentially capture, but then it's got to be for an anti-competitive purpose, which I can't imagine ever being enforceable. So where have we got to in our cartel rules? Well, unfortunately, I have to say to young Aussie, sorry, mate, D, which I think is a failure of the University of Queensland as it is at Monash University. Young Aussie must try harder in cartels and avoid being misled by political opportunism. Unfortunately, I think the politicians have got their jaws into this and are leading us off down the merry garden path in terms of where the reform should go. I can only hope that the people who drafted the legislation, and it looks like they did so, but it looks like they drafted it so it could be extended later on, very easily by Parliament, and I hope that's what is actually intended. Let me quickly go through the next two because I don't think they're as problematic. Abuse of market power. Now, our abuse of market power laws, Section 46(1) of the Competition and Consumer Act, a corporation that has a substantial degree of power in a market shall not take advantage of that power in that or any other market for the purpose of, and there's three purposes, basically doing nasty things to competitors. Now, this part of the Act has had a checkered history. It's had a history of ambiguity. But if you think of it from an economic point of view, that's exactly what you would expect. Good law against abuse of market power should have a lot of situations where there appears to be ambiguity. Why? Because what looks like an abuse of market power for an anti-competitive purpose often also looks like pro-competitive actions. Let's take a simple example. I happen to be a supermarket and I think, gosh, I would like to put my home brand milk on the shelves at $1 a litre. Completely random, fictitious example. Is that anti-competitive or pro-competitive? Am I doing that because I want to sell more other stuff? Because I want to get more customers into my stores? Or am I doing that because I hate Parmalat and the dairy farmers? Always worry about hating the dairy farmers because they've got to sell me the milk that I sell. But anyway, I get worried about that. I hate the dairy processors, though, like Parmalat, and I'm going to push them out of business by undermining their brand label milk on which they make significant profits. Am I doing this for an anti-competitive purpose or a pro-competitive purpose? It's hard to tell. It's going to depend on the facts. It's going to require somebody getting down and dirty and looking at actually what's going on. It's hard to distinguish between them. And the last thing you want is a law against abuse of market power that actually stops competitive behaviour. Competitors might like that, but from the point of view of consumers and the economy, we don't want that. The real problem with our abuse of market power laws is that politicians come under pressure, particularly from small business lobbies, to do something. Gosh, those guys over there have lowered prices. They're hurting me. Do something. I can't compete against them. It must be predatory. It must be anti-competitive because it's hurting me. It's stopping me competing because I can't match their prices. My costs may be higher. I may have inefficiency. I may not have as much bargaining power. But politicians feel under electoral pressure to do something. What's the result of that? Well, so far in Australia we've been pretty fortunate. The results have been some parliamentary inquiries. The milk inquiry's got lots of recommendations that I'm a little bit worried about, but let's see where they go. But so far the main effect has been some changes to the Act that have never been used. For example, the Birdsville Amendment. That's an amendment against predatory pricing. Now, why is it called the Birdsville Amendment? In support of the amendment, Senator Joyce, he's one of yours, stated in Parliament that, along with Bob Catter, Senator Joyce stated in Parliament that, I will be so presumptuous as to term the government amendment the Birdsville Amendment, because that is the town in which it was devised. It was devised in a motel room whilst I was travelling out to the west of Queensland. Taking that on board was a great step forward, not just for small business in Australia, but for the way in which small businesses throughout the world assess market share. Let it never be said that Senator Joyce is one for understatement. The Birdsville Amendment has never been used. It's never been used because it is bad law. It involves a bunch of terms that are not defined. It is not clear what is and is not legal under that law. You might want to say, well, if it's never been used, who cares? But it is sitting there. It creates uncertainty for the business community. And it's basically a politically inspired attempt to subvert Australia's competition laws. Now that's one example, one of a number. So what do we give young Aussie? I'll give young Aussie a B. Young Aussie's shown balance and foresight in the area of abuse of market power, but must be wary of the political bullies in the playground. So far, the effect has been limited, but I do get worried about it for future. Let me get to the third of the bread and butter issues, mergers. Our merger law's basically in line with international law. However, in Australia, we have the oddest process that I think exists anywhere. Unlike most countries, we do not have compulsory notification of mergers. So if two companies wish to merge, let's say Coles and Woolworths decided, let's merge. Formally, under our law, they do not have to tell the Australian Competition and Consumer Commission. They'd be a bit stupid if they didn't, because the ACCC, once they found out, could seek an injunction stopping the merger, or if the merger was consummated, the ACCC or any other party could seek to have the merger ruled unlawful, and one of the potential penalties would be divestiture, reversing the merger, unscrambling the egg. But formally they don't have to tell anyone. Because they don't have to informally tell anyone, an informal process of merger clearance has grown up in Australia since 1974. Basically, firms, Coles and Woolworths, if they wanted to merge, would go to the ACCC and say, "Hi guys, we're thinking of merging. What do you reckon?" Coles and Woolworths, it's probably a pretty quick no. But more formally, in the informal process, the ACCC would say, well, let's go out and ask the marketplace. And the mergers team at the ACCC would literally get on the phones and they would go and say, talk to competitors, talk to suppliers, talk to customers, try and get a feel for the marketplace, try and get a feel for what would happen if this merger went ahead. All done on a confidential basis. If they had concerns, they would feed them back to Coles and Woolworths, get their input, go back out to the marketplace. Very much an iterative process. If a Competition and Consumer Commission felt that its concerns were solidifying, it would put out what is called a Statement of Issues. Statement of Issues is basically a public document by the ACCC that says, we have concerns with this merger and here are our preliminary reasons why. Please give us more information if you agree or disagree. And they'd then do that iterative process some more. And if they decided not to allow the merger, and let's be a little bit careful what that means, if they decided the merger would be anti-competitive, they would say to Coles and Woolworths, look guys, you can go ahead and try and merge. Just tell us, if that's what you want to do, we will see you in the federal court on Monday morning because we will be seeking an injunction to stop you. We will try and convince a federal court judge on the basis of the evidence that we've collected, we will try and convince a federal court judge that that merger is a substantial lessening of competition. And that's where we are, for example, in Metcash Franklin's at the moment. It's going through that legal process. The Commission said no, Metcash said, sorry, we want to keep going. So the Commission said, great, we'll see you in court, which is where it's got to. Now, that informal process has changed over time. It depends very much on goodwill on both sides. And unfortunately, the ACCC blew it in terms of goodwill about 10 years ago in a case called AGL versus the ACCC. That was a situation that certainly preceded me as Mergers Commissioner, and the ACCC has said will never arise again. It was a situation where the ACCC basically said to AGL, they wanted to take over a part of a generator in Victoria, they said, look, we don't like this, but we don't think we've got the evidence to show it's anti-competitive at the moment. So I'll tell you what we'll do. We're not going to take you to court if you proceed now, but we do not guarantee you we won't take you to court in a year, 2 years, 3 years. So AGL said rude words to the ACCC, and marched off to the federal court and did what no one had done before, which is they said, we are going to the federal court to seek a federal court ruling that this is not anti-competitive. In other words, we, AGL, are taking the ACCC to court. And Justice French in that decision said that the ACCC's approach was like holding a sword of Damocles above the business community. And the ACCC lost that. There was pressure coming out of that which led to a bit of the Act that, like the Birdsville Amendment, has never been used. In the Competition and Consumer Act, there is an entire formal merger clearance process. It's been there for about 5 years now. It has never been used. It's a very public process. It's got set timelines. It's got a set way of appeal. Business doesn't seem to like it because of the public nature of the process, unlike the informal process, which is very much confidential. So no one's used it yet. Do we care? Yes. The formal process is a risk to the informal process. Why? Imagine that you're a public servant at the ACCC. If the formal process gets used once or twice, you're going to be sitting there saying, gosh, this formal process, it allows double dipping by the business community. They can go through the informal process. If they look like they're getting a no from that, they can go formal. And you know what? I don't get paid enough to put up with this crap of the informal process. Why should I, an underpaid bureaucrat at the ACCC, go through a process which depends purely on goodwill between the Commission and the business community when there is an entire formal process? And if I dot the I's and cross the T's, step 1, step 2, step 3, through the formal process, I completely cover myself. Why should I do this risky thing over here when there's a beautiful bureaucratic bit of law over here that I can use instead? And I've said for the last 5 years, I think that's the risk of the formal process. Not that the business community will use it, but once they start using it, the ACCC themselves will disavow the informal process. And essentially where we've seen this mix of formal and informal overseas, New Zealand being the best example, the formal has driven out the informal. And you've ended up with a less flexible situation that actually disadvantages the business community. So my prediction is that in 10 years' time, we will have one of two outcomes. Either the formal process will still have never been used, or, if it has been used, the informal merger clearance process, that depends on goodwill, will have disappeared. So my report card for mergers, rating B+, getting better. They actually get better through the report. Young Aussie's done a good job in balancing different incentives for mergers. However, in my opinion, that situation is unlikely to last. But we'll have to see. My final 10 or 15 minutes, what I want to talk about is some innovations in areas of competition regulation. And I'm going to talk about two innovations. First, what I call transparency reforms, and the second, reforms to switching costs. Why are these important? Transparency reforms are important because what these reforms do is they allow consumers to have trust that the market is working. They allow consumers to have faith that when they see a price or they see a representation being made by a firm, that they can trust that representation. And that's a good thing. That helps markets work better. It avoids a whole bunch of transaction costs that can act like grit in the wheels of the marketplace. And it's more likely to lead to economically efficient outcomes. Now, a couple of these that I want to run through. Substantiation notices is the first one. It's, for many years, been illegal to engage in misleading and deceptive conduct under our Trade Practices Act and then our competition and consumer laws. But the difficulty for the enforcement authority the ACCC today, is that they have to show that the behaviour was misleading and deceptive. What a substantiation notice does is it puts the onus on a business that if it makes claims in the marketplace, then the ACCC can say, you have 21 days in which to justify to us why you made those claims. So if, for example, and I'll pick a US case here, if, for example, I happen to sell pomegranate juice, and I claim that pomegranate juice is wonderful, it cures cancer, it stops baldness, it's just the best thing since sliced bread, the ACCC can say, hang on, I'm not sure that some of these are backed up. They can now issue a substantiation notice to the company and say, provide us with the documents or the information to allow us to see why you have made these claims, on what basis you have made them. So it's an investigative tool. And from my opinion, it's a pretty good investigative tool. It's not particularly onerous. I mean, after all, if you're making these claims, presumably you can back them up. The courts have distinguished between real claims and puffery. So, for example, if you happen to advertise drinking pomegranate juice and the person in the ad turns into Superman and flies over a building, the court will recognise that that's just marketing puffery, but you don't have to actually substantiate that the juice will allow people to fly over buildings. So it doesn't seem particularly onerous, but if you're making claims about place of origin, health claims, environmental claims, it makes that law just that bit easier to check out the scams and separate the scams and to punish them from the people who have real valid claims. So it seems like quite a nice way of just helping make the market a bit more transparent. What about the second one, clear pricing rules? Let me do another example. So Michael, I noticed Paul's disappeared over there, so obviously he was upset by the pricing one. So Michael, I'll pick on you. Welcome to Queensland, Michael, a fellow former Victorian. Michael, let's imagine that you come into my jewellery shop. And in my jewellery shop, I have this great offer for you. Diamond necklace. Used to be, I'm sure there's someone you'd want to buy a diamond necklace for, used to be $10,000, now $100. So, good deal. Courts have made clear through their decisions that if I make those sorts of claims, I have to have actually sold the diamond necklace for $10,000. I can't simply say, just claim we used to sell it for $10,000. Or I can't say, chuck a $10,000 price tag up on it, no one's going to buy it for that, but keep it up there for a week, then take it off and sell it for $100. So is pricing has been clarified by the courts. You can't simply come along and claim false information about what you were selling the goods at. The clear pricing laws have gone further from that. Anyone who bought a new car, basically up until about 3 or 4 years ago, would know that you had those great advertising campaigns, 19,999. You'd go into the dealer, you'd say, wow, I'd love to only pay 19,999 for that S-Class Mercedes. Unfortunately, down the bottom of the ad, there used to be things like includes $20,000 statutory duties and charges and delivery costs and anything else we can think of at the time. Little writing down the bottom of the ads. The clear pricing rules that we now have in Australia say no, you can't simply put up 19,999 in great big letters and hide a whole bunch of information about what's really the price down the bottom. Or if any of you have been caught, as I had in the past, sometimes going to a restaurant on the weekend, you say, gee, I thought this restaurant was more expensive, these prices don't look too bad. You get the bill at the end. Oh, I see, there's a 15 or a 20% surcharge because I happen to eat here on a weekend. That's now been made illegal. The clear pricing rules basically say that you have to make the actual price consumers pay both clear to the consumers and as least as obvious as any components that go up to that price. And you can't simply get away with saying, well, it's $25 plus 5% plus $2 plus whatever the chef out the back reckons is the fair thing at the time. You've got to actually have that final price clear for consumers. So again, it sounds like a relatively simple, cheap reform that helps consumers operate in the marketplace. They're going to be less wary, they can trust the information they receive. Do these sort of things make a difference? Has anyone gone back and actually checked whether these things are a good idea or not? I mean, it's possible that the fact that restaurants now, if they want a surcharge, have to have a weekday menu and a weekend menu, separate menus, because they can't just have the plus 10% down the bottom. And when these laws came in, the automotive industry said, it's going to be a disaster. How are we going to advertise cars? Well, it's called a drive-away price, and they all advertise drive-away prices now. They said, this is terrible. We won't be able to do national advertising campaigns because the state taxes differ. Well, they seem to have managed. But it's possible that the costs outweigh the benefits. Has anyone checked? Unfortunately, the answer is no, and if anyone's planning on doing honours or has a good honours student, I reckon these are some great areas to look at. But there is one we can look at, ATM reforms, which were really good and really were pioneered by Australia. Now, ATM, or automatic teller machine reforms, occurred in March 2009. Under the old system, if you, say, had a National Australia Bank account and you went to an ANZ teller machine, you would be charged. Except at the time, you would have no idea what the charge was. You'd find out at the end of a month when you read the back page of your monthly statement. And if you're like me and you never actually read your monthly bank statements, you would have no idea what you were ever being charged. The charge was about $2, $2.50 on these transactions. The reform that we made in Australia was basically really simple and from an economic perspective, almost costless, and if people were rational, utility maximisers, and there were no transactions costs, would have made no difference whatsoever. The Payment System Board, part of a Reserve Bank, said, look, rather than the owner of the ATM charging the National Australia Bank, my bank, and them then charging me monthly through the statement, if I go and use a foreign ATM, which is the technical name for them, not ATMs that have funny accents or anything like that, if I use a foreign ATM, then I must be informed of the charge on the screen before my transaction is complete, and I must have the option of stopping the transaction, saying, forget it, I'm not going ahead. Now remember, if everyone understood these fees, that should make no difference whatsoever. And in fact, from an empirical perspective, the average fee pretty much didn't change after these reforms. There were a number of other changes that occurred, and there were a number of good competitive changes, but the average fee actually didn't change very much. What was the change in consumer behaviour? This is straight from the Reserve Bank of Australia. The solid blue line represents, effectively, it's tracking the total withdrawals, the change in growth in total withdrawals from FPOS, ATMs or other. The real change, though, and you can see the change that occurred around March 2009, is between those pink lines and the blue lines. What happened in terms of growth of transactions is customers suddenly, when they became aware of the charges that they were facing at foreign ATMs, suddenly went, oops, I ain't taking my money out from that one anymore. The result, by the way, was that the banks suddenly faced a lot of pressure to extend their ATM networks, which they have done. FPOS, which was, and still remains today, a free alternative, obviously boomed. Customer behaviour changed a lot. Now, you could argue that from a standard economics perspective. You could say, look, reading your monthly statement has a bit of a cost associated. Customers didn't know what their charges were. This made them transparent. They changed their behaviour accordingly. You eliminated a little transaction cost. That's one interpretation. You could interpret it from behavioural economics. You could say, well, look, if you see the charge when you're making the decision, it means a lot more than if you see the charge at the end of a month. Now, I don't mind which of those arguments that you make, whether you say, look, this is just a rational consumer and we've eliminated a transaction cost, or it's a consumer who perhaps doesn't fit our standard models perfectly and what we've done is we've overcome a behavioural anomaly. I don't care. What you've got is a huge change in consumer behaviour where the information has changed but the price has not changed. That means consumers are making better decisions today. Now, by the way, the banks don't like this because those rising pink lines mean they don't get fees. Unsurprisingly, the banks are in the process of trying to change the way that FPOS is dealt with so that they can start charging fees on FPOS. The other thing that we see that backs up this as a good reform is we can actually go out and ask people, which the Reserve Bank's done, when they use a foreign ATM, why did they make that decision? Is it because they made a mistake and didn't realise the fee or not? Now, unfortunately, we don't have pre-reform information. So we don't know how many people before the reform simply weren't aware of the fees. I suspect it was a lot, but I don't have the evidence. But clearly, after the reforms, almost everybody who pays the fee now understands what they're doing and has made a choice to pay that fee. They're either in, for example, a venue where there is only an ATM where they pay a fee, it's too far to go to their own ATM, and so on. But do not know is that final little bar down the bottom, about 2%. So this reform has had huge effect on the marketplace on informing customers. So on transparency reforms, I'd say the report card rating is definitely an A. We are among the world leaders in these simple transparency reforms, and I think they are a really, really useful thing. Let me finish up because I'm out of time. Flavio's going to throw bread rolls at me in a second. Let me finish up by talking a bit about reducing switching costs. Why is this a good thing? Reducing switching costs is a good thing because there is absolutely no reason why we would expect a market to get to efficient switching costs, particularly in markets that involve network transactions. So, for example, if, as a group, banks have to decide on what is going to be the system for moving between banks and redirecting accounts or porting bank accounts, there is no reason we should expect those banks to sit there and say, hey, let's come up with a way that is the easiest for the customers. What we'd expect them to do is to come up with a joint system that raises customer switching costs. Because, hey, if Michael and I are both banks, that means his customers stay with him, mine stay with me, we can both jack up the prices. It's harder for competition to work. Similarly, in a system like the mobile phone network, there is no reason why we would expect the companies in that network to jointly agree to low switching costs. Economics doesn't give us any indication of why that would occur and in fact says the reverse. Now, Australia led the world in mobile number portability back in 2001. We were one of the first countries to introduce that. We're one of the fastest countries in the world still. Basically, if you want to switch your mobile number, you go to your new carrier and say to the carrier, this is my number, and it takes approximately 3 minutes. The carrier then gets on their system, they dial in or they put in your old number. Within about 3 minutes, that number is ported. It's about the fastest in the world. Some European countries still take about 3 weeks. I should have looked up and seen if it was Greece or Italy. I suspect it probably is. But it has led to an increase in mobile phone competition in Australia. You don't want to have to change your number every time you change your mobile phone carrier, and if you did, you wouldn't change your carrier as much because it's a pain in the rear end. You don't have to do that now. We were one of the first. Most countries around the world have followed. Singapore was formerly the first, but their system wasn't as good as ours. What about bank account portability? That's one that's being looked at the moment. It's being looked at by the Independent Commission on Banking in the UK, the Vickers report, and it basically said full portability is a bit too expensive. They've recommended the introduction of a redirection service for bank accounts. So basically you have a year, you can go to a new bank, your new bank will contact the old bank, and for a year your old bank has to redirect any automatic debits or credits through to the new bank. It gives you a year to get your house in order, to get the changes through to your suppliers or to your customers or whoever the redirection or whoever the debits and credits are going to. It decided that full account portability was too expensive. In Australia, just a few months ago, Bernie Fraser put out a report where he basically said the same thing. Implementation of full account portability, however, would be far from simple and not at all analogous to mobile phone portability, as sometimes suggested. It would involve the replacement of the bank-state branch system, of numbering and the wholesale revamping of the existing payment infrastructure. The reason for that is that our financial system works on bilateral contracts and arrangements, whereas our telephone system has a central database. So if you make a call, your carrier looks at the central database, says, the number you're ringing belongs to X, and then puts you onto X's network, and they find you. With the banks, unfortunately, there is no central database. Bank A talks to Bank B, which might talk to ATM provider C, which might talk to credit card company D, and so on, all in this mesh of transactions. And account portability depends essentially on a central database. And what Bernie Fraser said was, guys, it's just way too expensive to try and completely restructure our system and set up a central database. However, he has suggested a form of moderated switching. In quite a clever innovation, he said, actually, what we can do in Australia is build on a system that we've already got, and essentially, by signing one document, customers will be able to get their new bank to get the information from their old bank on all their debits and credits, their automatic debits and credits, and your new bank will be able to inform the relevant parties of your new account numbers. So from the customer's perspective, pretty simple. So again, report card rating A, Australia's again leading the world on some of this stuff. It really would be nice, and again, if any of you have got honours students or PhD students who'd like to look at some of these changes and do retrospectives, see have they really made a difference. My feeling is yes, ATMs is the one we've got the most information on, but gee, it'd be great to know. But in these areas, Australia's really leading the world. So, what's my conclusion? Overall, Australia's actually done pretty well. So Stephen grabbed me on the way and I said, I hope it's an A+ for everything. Well, yeah, not quite. But certainly there's a few A's in there and just that one nasty D on cartels. Particularly in the regulatory innovation, Australia's leading the world, and that really shouldn't come as a surprise because we've been doing it for the last 20 years. National competition policy back in the 90s was world-leading regulatory innovation. It's interesting if you follow Indian press. I have no idea why you do it. My wife's Indian, so I follow the Indian press. They're actually introducing national competition policy over there, taking from the Australian example, because they view it as an anti-corruption measure. The sort of transparency that we put on government transactions in Australia under national competition policy is a great way to stop graft and corruption. I'm not sure that was the driver here, but it's certainly the driver in India. I've just had a conversation about 2 days ago with some of the Europeans who are looking at the Greek problems and the problems in their economy, and they wanted to know about Australia's national competition policy because they said the innovations you did 20 years ago, my God, if only we can do them to the Greek economy. My response was, it took about 20 years to get them in Australia. You've got less than 20 months. You've got about 2 months. So I wish them luck. Now, our innovations aren't finished. There's still a whole range of things we can do. Credit cards is one of my favourites, where I think we can be more innovative. But we're doing really well in that. Unfortunately, it's our performance in traditional areas of antitrust that's weaker. So our cartel laws are narrow by international standards. The price signalling amendments, why banks? Why not extend them more fully? And we have these dormant bits of the Act that create risks for business and I think create risks for where we'll be in 10 years' time in terms of our competition laws. So overall, Australia should be proud of its successes in competition regulation. However, as I suspect is the bottom line, those of you who have kids at school, bottom line of almost any report card, young Aussie can do better. Thank you.
Thank you, Stephen. We have about 3 minutes for questions before I ask Adrian to come up and say a vote of thanks. Just to kick off, I'd just like to ask the same question we ask other commissioners and former commissioners of the ACCC. I'll be as quick as possible. So one issue with regulation, and in particular with competition regulations, that if you have good regulation or good competition regulation, you don't hear about it, right? You know, transactions or actions that might have taken place, they don't take place. So one issue is how you evaluate ex post regulatory decisions, and this includes mergers and so on and so forth. So the issue is how you, is it important to do an ex post evaluation of merger decisions, and if you do, how would you go about doing it?
The answer is yes, it's very important, particularly in mergers. How would you go about it? The US Department of Justice have actually done it. They've looked at about 10 years' worth of mergers and gone back, looked at what happened to the industry afterwards. You obviously have to look both at mergers where you stop the transaction and mergers where you allow the transaction to go ahead but had some concerns about it, and try and tease out, were the decisions correct or were the decisions incorrect? Is it important? Yes, particularly on mergers. Mergers is an odd bit of law if you think about it. Other bits of law say, you've done something wrong. You were speeding. You were price fixing. Therefore, if we've got the evidence, we'll prosecute you and you'll receive the punishment. Mergers is a situation where we say, gosh, we're going to stop this transaction because we believe that in the future this may reduce competition. So mergers by its very nature is crystal ball gazing. And in fact, the Metcash fight, a lot of it is about, the ACCC's crystal ball and whether it was a bit foggy that day. So it's really important, particularly on mergers, to ex post analyse them. Have they done it overseas? Yes. Could we learn from them and do it here? Yes. Have we done it? No. Do I expect the ACCC to do it? Unfortunately, I suspect the answer is no.
That was the answer. I got it. And part of the rationale was, concerns about undermining the decisions. Well, if the decision was wrong, you exactly want to undermine it. Anyway, we do have time for maybe a couple of quick questions. Michael, there's a microphone coming just behind you.
All right. Stephen, when Paul was here, we were talking about how countries who are resource-rich, like Australia and Nigeria, tend to do really dumb things because they have so much resource money. And the reason they can do really dumb things and get away with it, why politicians can get really dumb things and get away with it, is because nobody misses the money. Now, you were talking before about the Birdsville Act. Now, I have stood on the same platform as Barnaby Joyce, and I have spoken with him. And I think a better explanation than of him as being, rather than being a political bully, is that he is capable of doing things which are really, really dumb. How does one guard against? I mean, if you want to make this efficient, functional legislation, and you have a tendency for politicians to do things which are really, really dumb, how do you guard against that in moving forward to more functional policy? Okay.
I think we actually put up a really good process to guard against that coming out of our 1990 competition policy reforms with the legislative review. And if you remember, coming out of COAG at that time was a commitment by state and federal governments to review legislation, look at if they acted against the interests of competition, so reduce competition, cause competitive harm. If they did so, were there offsetting benefits? If there were offsetting benefits, did they outweigh the costs? And even in that situation, where the costs outweighed the benefits, was there a more pro-competitive way of getting those same benefits? Now, what's happened, and if you remember, that led to, at the time, some pretty good looks at legislation to try and work out, was this legislation desirable or not? So a proper cost-benefit analysis of regulation. Now, formally that is meant to occur every 10 years. Formally we still have regulatory impact statements, but unfortunately in Australia that's now all become pretty stock standard for most legislation. So what's ended up happening is we've got an agreement that is really being done to the minimal degree. It's really not doing the job that it should have been doing. I actually think that having a separate body like the NCC, having a rigorous approach where we say, well, okay, the government passes legislation, but the government's also committed that it will look at legislation in this lens and it will be quite public in those terms, that could actually offset a lot of the poor legislation. If there was actually, in a sense, this third party who could say, well, you're the government, you can do what we're not legislators, but as part of that legislative process, here is a public process, we will look at the costs and benefits of that legislation and see if the benefits outweigh the detriments. And you can pass it, you're the government, but publicly that information will still come out. I think if we could have more of that and get back to that sort of shining the torchlight, I think that would be a good thing. But other than that, politicians will respond to electoral pressure, whether through guile or through ignorance.
We only have really time for one more question, quick question. No? All right. Cool.
You talk them out of it, don't you?
Anyway, can Agent Noon from Queensland Treasury, can you please come up and say a vote of thanks to Stephen? Thank you.
Thanks, Flavio. My name's Adrian Noon. Most people in the room probably know me. I'm the Executive Director of Office at Government-Owned Corporations, Queensland Treasury. Queensland Treasury have supported this event for many years. It's a great event in honour of a great Australian economist and Queensland economist. I did my honours at UQ Economics back in the mid-80s, and I can remember those years when Professor Clark was often in the common room at UQ Economics. And we were all made well aware of his great achievements while we were there. This series has now been going 21 years. I've been lucky to make most of the presentations over the years. There's a great honour board of past presenters of this series. If you look on the back of the handout today, you'll see names like Angus Maddison, Ian McFarlane, Bob Gregory, Ian Castles. And I think it's... for myself as a person who lives and breathes trade practices and cartels and third-party access and all that stuff every single day of my working life, I think it's most appropriate that Stephen joins that honour board today. Stephen is a great contemporary Australian economist. He's someone who's, if you have a look at his CV off the website for Monash, it goes for about 14 pages and it's got hundreds and hundreds of papers. So I don't pretend to have read all your papers, mate. But I have read quite a lot over the years. Stephen was at the ACCC for many years, and so he's not only he's an economist who's not only an academic, he's put his work into practice. People may not be aware Stephen is still a lay member of the New Zealand High Court and still advises the New Zealand High Court on economic aspects of the cases that come before them. I think today's talk has been a great talk. As I said, as somebody who lives and breathes this stuff every day, we need constant reminders of what's the purpose and benefits behind the Hilmer reforms, which are amongst the greatest reforms, in my view, as an economist, practicing economist, ever put in place in this country. And it's very timely to go through what's worked and what perhaps could work a bit better. I probably myself wouldn't give cartels a D, but I can see why you went the way you did. But I agree, a lot of the other parts of Australian law is very good, and I'm a great supporter of these very simple but very effective reforms that have been put in place, like the ATM reforms, and like the stuff with how people can advertise cars and how restaurants can price their meals and all the rest of it. It's simple stuff that costs next to nothing, and it gives consumers information. One of the greatest failings in a typical unregulated market is information asymmetry, because the service provider usually has all the information, and it's not always possible for the consumer to get it. So without further ado, I'd ask everybody to give Stephen the appropriate applause for a great talk today, and certainly a talk I found very interesting and very challenging. Thank you. There's a couple of goodies here for him. Fabio's asked me to close proceedings. We've gone a little bit over time. I think my lift's waiting for me out the front. So with that, I close today's proceedings. It's been another great Colin Clark lecture, and I'm looking forward to next year and see who we can manage to score for next year. Flavio's got something else to say, guys.
I wish I had the excuse that I have had too much wine. I actually haven't drunk. So anyway, I forgot to mention that next year's Colin Clark lecturer is Ross Garneau, and but it's going to be the first week of September. Louise, do you remember the date? The 3rd of September. So if you could put in your diaries, the 3rd of September, Ross Garneau. And thanks very much. And I apologize for going 5 minutes after 2 o'clock. Thank you very much.